Welcome to Just Verdicts with your host, Brendan Lupetin, a podcast dedicated to the pursuit of just verdicts for just cases. Join us for in-depth interviews and discussions of cutting-edge trial strategies that will give you the keys to conquering the courtroom. Produced and powered by LawPods.
Today on Just Verdicts, we're talking with Kline and Specter partner Dominic Guerrini about a recent verdict that he got up in Erie County just a couple of weeks ago. Is that right, Dom? Welcome to the show. Thanks for being here, man.
Thanks very much for having me, and that is in fact correct.
I always like when we get people fresh off the heels of victory. That way, they haven't forgotten anything. They're still riding a bit of the high from it. So first off, congratulations. That's an awesome verdict.
Thanks very much.
And of course, thank you for being here. And as I was telling you before we signed on, I'm kind of a trial geek and have been for a long time. And I remember the first time I kind of became aware of you was I was sitting through the Goretzka trial. And that's a long time ago now. And I remember, I obviously knew who Shanin was. And then I see, you and Kyla there, trying this case with him. And, I couldn't help but be a little envious, I guess I would say. And then really kept track of both you and Kyla as the years have gone on. And not surprisingly, you've crushed it with tons of amazing verdicts since then. But I told you I was hoping you'd indulge me a little bit about, if you could just kind of give me an overview, outsider looking in, what it's been like your journey starting as an associate and then rising up, Kline and Specter, all these, just big names, big reputation firm. I mean, what has it been like? As much as you can tell me on a podcast like this.
Sure. In short, it's been an amazing ride. I feel like I've been very fortunate and very lucky to sort of work my way up at the firm. And I don't think that there is a place where you could get better training. I started with Kline and Specter as a lawyer 3 months into my legal career. I spent 3 months at a big corporate Philadelphia firm. And I had spent part of my law school career at Kline and Specter, and that's where I wanted to be. And a position opened up in December of 2003 when I was literally 3 months into practice. And they asked me how quickly I could start, and I said tomorrow. And looking back on it, it's truly one of the best decisions that I could have made. Tom Kline and Shanin Specter are just two of the giants, and to be able to work with them for 20 plus years now, doing the work and doing cases with them, you almost don't realize that you're learning by sitting at their feet and by carrying their bags and by second chairing and eventually working your way up. But then when it comes time for you to stand on your own 2 feet, it's almost like intuitive because you have spent so much time watching them do it, watching how they handle the situation, so that when you have an issue that comes up in a case, you are ready to go because you've seen it before and you know how two of the best have dealt with the situation. So I started at Kline and Specter in 2003. It was a completely different firm then. I think we had 15 or 16 lawyers, and there have been different iterations, different groups of lawyers have come and gone. But it's just been a great place for me because the cases are amazing. The training has been outstanding, and it's really just allowed me to grow my practice and to try really excellent cases in a wonderful and respectful environment. So I can't say enough good things about my upbringing at Kline and Specter and how it's really been a springboard to allow me to get some verdicts.
You have a great bio on the firm webpage, and it leads off with how things started for you, taking a trial ed class with Shanin Specter, doing really well in it. Did you have a sense of wanting to become a plaintiff's trial lawyer prior to that class, or did that kind of crystallize like, hey, this is something I think I'd really like to do?
I definitely had it in mind before that class, and that class certainly solidified it in my mind. So my best friend growing up, his dad was a trial lawyer in New Jersey, and it just seemed like he had a cool job, and he enjoyed what he did, and he made a nice living. And I was the son of two public school music teachers, and so it just seemed interesting to me. Like this would be a good route to take. So that was inspiration number one. And then inspiration number two, during my first summer of law school, I was a summer associate at a firm in Delaware called Young Conaway. And they were a big corporate firm, which is where students from Penn were supposed to go, do the big corporate thing, big law. And this firm was interesting in that it, in addition to being a big corporate firm, had a small sort of vestigial plaintiff's personal injury practice. And so I spent most of that summer working with that group and that practice. And it, again, just solidified things in my mind that this is rewarding, and this is how I'd like to have a career.
Over the years, obviously you've been fortunate enough to, work with, learn from, Tom Kline, Shanin Specter, and I mean, just a ton of other amazing trial lawyers at your firm. Some are still there. Some have been there in the past. What would you say have been over the years like the biggest influences on the way you look and strategize about trying a case? Whether it's books, whether it was what you learned from the people that you work with, a combination of them. Like if you look back, what are some of the biggest influences on how you think about how best to try a case?
So I still am learning, and I still am honing my craft. But two of the biggest influences, one from Shanin and one from Tom, because they are two very different people and they have very different styles preparing cases and in the courtroom. With Shanin, I have really learned the value of preparation so that literally every last detail is buttoned up before you get in front of a jury, so that when that time comes, you are ready to go. And anything that may arise during the course of the trial, you have prepared for and is coming. And that, legal issues, witness issues. So the benefit of preparation and just spending the time to get your ducks in a row before you start the trial, that is something that I have that Shanin has just drilled into my head. And then with Tom, it's the art of the presentation, and it's getting the jury interested and putting on a show so that the jury is entertained and they are engaged, and the importance of doing that to keep them with you and to keep them paying attention to what it is that you have to say. So those are two of the more general things, but I'm still learning. In this trial, we did a couple of things that I had literally never done before, that I had picked up from some other trial lawyers that I work with, even outside the firm. So I feel like we continue to hone our craft, and just because I've been brought up by Tom and Shanin doesn't mean that everything that they do, I have to continue to do it exactly the same way. I can, take the best and then make it my own.
I was at a Mark Lanier conference years ago, and he said every trial that he does, he tries to do at least one new thing, like incorporate one new concept, visual technique, demonstrative argument, something, new, so that, evolving, always improving. And again, I think a big takeaway you said there is whatever you learn from other people, books, seminars, etc., you have to take it and make it your own, or else it doesn't, I think, come off authentically.
I completely agree. I cannot be Tom Kline. That's not who I am. I cannot be Shanin Specter. That's not who I am. But I can learn from both of them, and I can learn from others at my firm, and I can incorporate the things that they do into my presentation and make it me. And I think that was something that was hard for me to learn at first. When I first started at Kline and Specter, I had a different demeanor. I had a different outlook. I was probably a little nastier because I thought, that's how you're supposed to be, but that's really not my personality. I can be tough, I can be forceful, but I don't have to be a jerk. And learning to be myself uh, throughout the preparation of the case and then in front of the jury, I think is really important. One of the the last case that I tried to a defense verdict, my paralegal came to me afterwards and she said, I think you need to smile more. I think you need to show the jury who you are. And I think it would be better for you if they could see the person that I see every day. And literally years and years later, that has stuck with me so that I can put myself in front of the jury. I can be myself in front of the jury while obviously incorporating all the training and education that I've received.
Yeah, I think that's phenomenal advice. Sometimes hard to do when you're under the pressure of trial to be yourself. I think when things are going well, you're kind of the best version of yourself in trial. But when you're under a ton of pressure, it's a tough case. That's sometimes you get so stressed out. And yeah, sometimes I find myself, I'm like, God, what am I doing? This is not me. And I think it's important to keep that in mind. I'll give you a little bit of a hard time for a second, because I'm scrolling through your bio and you can sort of, you have like this chronology in there. And some of your older pictures when you were young, you look a lot more, brash and, like the tough, shark in court. And then here, ever since I've talked with you, always so laid back, nice, sweet guy. And that's probably who you've always been, right? And I guess maybe we're always trying to find our true selves, right?
Exactly. I got brought up watching some guys take depositions, and I mean, honestly, at the beginning of Kline and Specter, it was at that point very male heavy, and some of those guys, their style was to just be that shark and be brash and really go for the throat every single time. And can I do that? Yeah, but it doesn't feel authentic to me, and I feel like for me there are different ways of getting to the same place where I can do that, but also be true to my personality.
So, and I need you to remind me because I forget things that I want to hear about, some of the new, trial concepts or whatever it was that you incorporated into this case. But I want to get into the Mitchell versus St. Vincent's Hospital case, that you got this recent great verdict on. So can you, tell us about, a summary of what this case involved and, what happened to this young woman?
Yeah, so Allison Mitchell was 23 years old. She was at a retreat at her mom's church, and she suddenly collapsed in the women's room after not feeling well. She had a terrible headache. According to the EMT record, she was unconscious for approximately 5 minutes, which became an issue in the case. And the EMTs learned at the time that they came to her side that she had been taking birth control pills. They brought her to St. Vincent's Hospital, where she was seen in the emergency department. They ran some tests there, including a CT scan without contrast. And that CT scan was ultimately misread, which became one of the main pillars of our case. But even putting aside the misreading of the CT scan, she was admitted to the hospital. And the plan at the time of admission was if she continues to have headaches, then we need to do an MRI on her and we need to consult neurology. And they kept Allison in the hospital for the next 3 days. And Allison continued to have headaches. And unfortunately, the hospitalist team that was caring for her did not know that she was taking birth control pills because birth control pills are a major risk factor in developing the condition that she was ultimately found to have, which was cerebral venous thrombosis, or what we called CVT, blood clots in the brain. So anyway, Allison was kept in the hospital for 3 days. She was discharged with a diagnosis of urinary tract infection, which didn't make a whole heck of a lot of sense to us. And she was just kind of a mess for the next several days. She went to her home. She couldn't be left alone. Her mom was basically responsible for her care. And at some point in time, she started to have issues with her vision. Her vision became blurred. So she reached out, her mom reached out to the primary care team to make an appointment. The primary care team made an appointment for her several days later. Allison went to that appointment, and by that point, her vision had severely decompensated. She went back to St. Vincent's, and they diagnosed her a day later with CVT. And unfortunately, by that point, it was just too late. And she had lost a significant amount of her vision and become legally blind at the age of 23.
Dom, during that first, well, I guess the only real, well, no, the first admission at St. Vincent, so they do a CT scan, which is sort of standard protocol for a patient like this with headaches, et cetera, and they read it largely as negative, right? But I think, was there a suggestion by somebody that there possibly should be an MRI followed up on?
Yeah, so what happened was St. Vincent's has a system in place where the radiologists are not in-house. So they contract with an outside company called Foundation Radiology, or they did at the time. And those radiologists are literally scattered around the country reading these studies. It happened to be that this radiologist, Dr. Bardwaj, was located outside of Philadelphia in Norristown, Pennsylvania. And he read it as a completely normal study. And his take was that this is not a study that one would order to look for CVT, but rather a study that one would use to look for bleeds, ischemia, things of that nature, essentially a stroke. And because he didn't see a stroke, I don't know that he looked further for clots. He read the study as normal, but in what I believe to be sort of a CYA that is included with a read like this, he said MRIs are more sensitive if you are concerned about headaches, would recommend MRI for further evaluation. And what the hospitalist team said was, we hear that all the time. That is sort of the footnote to every head CT that we get. So they didn't really put any stock in it. And of course, the radiologist argued, I did my job. I told them they need to get an MRI. They didn't get an MRI, and they should have done so.
So over the 3 days that she was admitted, she did not have any further head imaging?
She did not.
Ah, okay. And separate and apart, so you can clearly see how that would be an issue for, was that a hospitalist group?
It was. So that was a hospitalist group, again, employed by a company known as Apogee, which employs hospitalists at different hospitals literally around the country.
Okay.
So there was a nurse practitioner who was involved in the admission. She was supervised by a hospitalist, and then they went off shift on the second day, and another hospitalist then became responsible for Allison.
Separately, did you have support regarding whether the radiologist had missed any obvious findings on the original CT read that should have said in and of themselves, this is a concerning study?
Yeah, so that ultimately became the case. In radiology cases, what I like to, my standard in a radiology case is, can I see it? Is it obvious to me? Is the miss that such that if I can see it, I'm comfortable that a juror can then see it? And with a CT scan, there are multiple still images that are compiled together in a series. And what we saw with the benefit of our expert was that there were clearly clots present and that were visible and frankly obvious on the CT scan. And so that became theory number one, that the radiologist just simply missed it. And in addition to my training at Penn, I went through an LLM in trial advocacy at Temple. And when I went through that program, what was ingrained in me was come up with a theory. You have to have a theory. There's got to be a theory. And so theory number one at trial became recognize the obvious. And so this radiologist failed to recognize the obvious. That was theory number one. And then theory number two, which sort of changed at the time of trial based on settlement negotiations and the result of those, the theory against the hospitalist was you need to follow the plan. The plan was to get an MRI. If she continued to have headaches, you didn't follow the plan. So I like to have these sound bites as themes and theories that a jury can go back into the deliberation room and just repeat and repeat and repeat, that are just easy and they stick with you. So those were our two main theories here.
As far as how you filed this suit, am I correct that the only named defendant was AHN St. Vincent?
No, we named a number of different parties. So
Okay.
we named St. Vincent's, we named Apogee, who employed the hospitalists. We named each of the hospitalists who were involved. We named the nurse practitioner. We named the radiologist, and then we named the company foundation that employed the radiologist.
So can you sort of from a strategic sense, and I know that I think you mentioned that maybe there was some type of a joint tort settlement or something along those lines, but can you talk a little bit about sort of your approach when you have these multi-defendant situations can sometimes be tricky. I mean, do you like present it as, sort of compartmentalized cases? This is the case against the radiology group. This is the case against the hospitals. This is the case against of why the hospital itself is at fault. Or does it kind of just all become, a combined story?
Yeah. So I would have presented it as a combined story. And the thing to keep in mind here was the radiologist was an agent of the hospital. The hospitalists were agents of the hospital. The nurse practitioner was an agent of the hospital. So I had St. Vincent's, in theory, backstopping and paying excess on any verdict that I would get against any of those defendants. And it sort of put me in a really comfortable position because the way the case was worked up in discovery was I thought I had him coming and going. I thought I had the radiologist because I thought it was a clear miss. And then I thought that I had the hospitalists because they had they had issued a plan that was black and white, and then they didn't follow the plan and they didn't get some critical information along the way. And so I thought that there was a good chance that the hospitalists would blame the radiologist, and they would say, this guy blew the read, and if he had told us what was there, we would have pursued a completely different diagnosis. And then I thought that the radiologist was going to blame the hospitalists because he was going to say, I told them to get an MRI. They didn't listen to me. That's on them. And on either case, I had St. Vincent's and AHN behind it. So it was a good place to be.
Now, while from a going to trial perspective, you like the dynamic that is set up with the hospital backstopping sort of the most culpable parties. And again, to the extent that you can talk about settlement and all, but I find in those situations that the settlement negotiations can be tricky, though, because here the actual employers of the individuals are different than the hospital, and then the hospital is saying, well, no, they should be paying their fair share, and it can get really messy with as far as people finally saying, hey, okay, we're going to pony up and pay money to get this case settled, and everybody's pointing and saying somebody else should pay first before we pay and so forth. I don't know. That's a difficult dynamic, and I imagine you probably ran into that to some extent in this case.
It was. And the other thing that bears mentioning is that this was the second iteration of this case because we had tried the case in January. We had started the case, we had opened, I had put on the first witness. And then because a defense expert witness became unavailable due to a health issue, uh, very early on into that case, Judge Ridge declared a mistrial. And so I was at that point in time kind of depressed about the situation because the case had started so well for us, and I was just so pleased with the testimony that I had gotten, and I thought that we were on our way to a really strong result. And I was frankly pissed that there was this mistrial, but the mistrial really turned into, I think, the fulcrum that allowed us to settle part of the case because what we did during the first trial was we put the nurse practitioner on. I called her as on cross, and her testimony was really damaging. And she made a number of admissions that they weren't going to be able to get away from. Things that she knows she should have done, things that she didn't do. And so, whatever admissions I got in that first trial, I knew I was going to be able to use against them in the second trial. And I think they knew that too. And so ultimately, where it got us was a joint tortfeasor release that essentially settled out the hospitalist claims for a sum of money. So all of those claims were settled. And then trial became primarily about the claims against the radiologist. But the settlement happened early on in the second trial, and the jury had met the lawyer for the hospital and met the lawyer for the hospitalists. And so those lawyers continued to defend their clients in the second trial. And we decided that in order to uh, not have the jury ask questions and not have the jury wonder what the heck is going on, we actually put on a soft case against the hospitalists, enough to get to the jury, while telling the jury this is really the radiologist's fault and the hospitalists were hamstrung by what the radiologist did here.
Well, that probably, I mean, didn't that somewhat negatively impact, I mean, just because you gave an opening that probably was not as heavy focused on just a radiologist, right? And then you settle that part of the case, or did that settlement happen before that second trial?
It happened just before the openings, but after
Okay.
jury selection.
Okay.
So I was able to get up in the openings and say, these people all messed up, but this is really on the radiologist. And the opening became about the imaging. I showed the imaging in my opening, and it was the first time, coming from Philadelphia, we joke about the jurors like being with you and getting like visual cues from them where they're nodding their heads and like they're showing you that they're with you. And it was literally the first time in my career where I had given an opening where I had people nodding along with me in the opening when I showed the imaging because I presented it as obvious and they saw it. And I think that cast the die for the radiology case pretty early on.
Yeah, yeah. Did you? I've never. I'm trying to think. I don't think I've retried a mistried case before. So did you have the same jury, or did you have to impanel a whole new jury the second time around?
Completely different jury.
Okay. What was and did Judge Ridge preside over both trials?
He did.
Tell us about the jury selection process that Judge Ridge utilizes. Erie, personally, the two I've tried up there recently, I love their jury selection process. I don't know if this is how he did it, but it was the old school, open, talk to everybody in the veneer kind of voir dire where you had free reign. Does he do it that way also, or is his different?
He did it a little bit differently this time, and he was, I think, wanting to make sure that we finished our trial by a set date. like there was just no going past that date. And so things were geared towards making sure that we were efficient with the time. So the jury selection was, an open veneer panel where you would ask your questions that would elicit yes or no responses. And then once you finished all of those yes or no questions, any potential jury member who had answered a question in the open section would then get called up to sidebar, and we would be able to question them at sidebar.
Okay, but not so much like having people crosstalk and having a full-blown conversation like, hey, Bill, like, can you respond? I saw you nodding along to Sally's response there kind of thing.
No, he didn't want that communication happening in front of the entire panel.
Gotcha. So you select this jury second time around. Having tried it the first time, as frustrating as that had to be, when you feel like you've got the momentum going the first time and then you get a mistrial, was there anything that you gathered? Like in a sense, it's almost like a mini mock trial or mini focus group, sort of like how the defense was going to argue. I mean, you got a major preview of from the first time what they were going to say and how they're going to defend the case. So how did that factor into the way you prepared and tried the second trial?
Not a lot. What factored in was the feedback that we got from the jurors that we talked to after the mistrial. There was an issue in the case. There were a couple of small issues in the case that I joke you gave me a little bit of heartburn. That's like my standard. And one of those issues was the fact that Allison was discharged to home and then didn't return back to the hospital for 3 days while her vision appears to be getting worse. And a major focus of the defense in the case was essentially to blame Allison and to put some percentage on Allison and say, she really, this is partially her fault. She should have gone back to the hospital sooner. And the fact that she didn't, you should hold that against her. So that issue became much more apparent in the first trial. And the other thing we learned in the first trial was while the radiologist and the hospitalists had sort of played nice in the sandbox with one another up until the time of trial, once trial started, the gloves came off and the finger pointing started. So we knew that was coming. And obviously, when you have defendants who are pointing the finger at one another, it's our best day.
100%. So talk to me about, because it's always a concern in every case. I think medical negligence cases in particular, the attribution bias, I would have done something different, and holding, somebody like your client to a much higher standard than really anybody would have for themselves. How did you deal with that sort of implied comparative fault argument?
A couple of different ways. So number one, we elicited testimony from Allison and from her mom that Allison was essentially incapacitated during those several days and did nothing other than lay on the couch. We elicited testimony that she was not able to drive, that she was not able to care for herself, and that she could not be left alone. So we made it, the argument was, what would a reasonable person in Allison's situation do? And a reasonable person in Allison's situation was not capable of making a decision. We got testimony from mom that mom was responsible for Allison's care. So the idea was to sort of put this on mom, who's obviously not on the verdict slip, and for her to own the failure to go back sooner. The other thing we did is we had a neurology expert who testified on causation. And we had him describe essentially the process of CVT and the impact that it has on one's ability to think and to process, so as to give the jury an understanding that Allison really wasn't all there and really wasn't in a position to be making decisions for herself. I thought all of that testimony went in just about as well as it could have gone in. And to the extent that you can be pissed about a good verdict, I was pissed that the jury did assign 10% to Allison for comparative. I just didn't think that there was any any evidence that would allow them to do it. I thought that the evidence that was presented was, if anything, her parents made a mistake, and her parents should have done differently, but there was nothing that Allison should have done differently.
Learning that information, that obviously was helpful for you, knowing, particular landmine that you had to address the second time around. Did you change your opening, the way that you sort of undermined or inoculated that issue compared to how you did it the first time around?
I did. I started setting up the idea of this lack of capacity, this lack of ability to make decisions, in a way that I didn't really treat it as much of an issue going into the first trial. I didn't see it as something that could be pinned on Allison. And so I just didn't focus on it very much. But when we started hearing things like personal responsibility and these defense slogans, we got out in front of it in the opening this time.
Yeah, I mean, it's in every case, I think, even if they're not even making a formal comparative, fault claim. I think it's in so many cases, unless there's absolutely nothing, like it was a surgical error or something like that, where your patient literally couldn't. And even then, sometimes people are thinking, well, your patient shouldn't have, been doing whatever they did to lead them to be, in that condition in the first place, to need medical care. I mean, it's a tough spot. And I think no matter what, even if it's not as big of an issue as you learned, you always have to kind of weave that into your cases, that you have to show that your client is a responsible person, a detail-oriented person, that kind of thing. Just from the impression that they give off, I think that can only help. And sometimes if you don't do that, I think that it can, hurt you even in cases where there is no comparative fault question.
I was even a little more fiery the first time around, and I was probably a little too aggressive in my opening. You're going to hear this, basically like, how dare they? And I think that was, that became my closing a little bit this time around, because I think if defendants are unsuccessful with using that as a defense and they try to blame the plaintiff, I think that can really tick a jury off, and really allow a verdict to explode. And I don't think that happened here. Obviously, when they found her 10%, I was hoping that a jury would get angry that they were blaming Allison, especially because this was a weird case for me, where the defendant radiologist literally never took the stand. I didn't choose to call him as on cross-examination for strategic reasons, thinking that the defense would then just call him in their case, and they never did. So this jury never heard from the defendant whose care was at issue. They don't know anything about him. They don't know where he was trained. Nothing was presented. And for me, they're going to blame the plaintiff and say that she needs to take responsibility when their radiologist wouldn't even come and take the stand. I thought that was going to end differently for us.
Okay, two questions for you. One, have you ever in your career in a case not had essentially a party not give testimony in the case, other than if they had died prior to trial? And B, why do you think the defense did that?
So to answer the first question, I have never seen that before. And I did not know until this case that there is actually a standard jury instruction in Pennsylvania that allows the jury to take an adverse inference from a defendant's failure to take the stand. We didn't ultimately get that adverse inference here, at least not from the court, although I argued it in closing anyway.
Yeah, right.
So I have never, ever seen that before. And I think the reason why: he was not a particularly good witness. I had done a pretty strong cross-examination of his radiology expert, which was among the more fun expert crosses I have done in my career, just because there was so much material to work with. And I think they felt that if he testified, that he was going to have a similar experience.
That's really bizarre. Even still, I mean, I've had so many, doctor or medical witnesses who were most likely going to be terrible witnesses, but there was never a doubt that they were going to be called. Just because I think people were like, how could you not call, one of the main people in the case? Can you talk a little bit about so radiology cases are unique in their own right. I mean, you actually have the image there, but sometimes, I mean, it's difficult. You're trying to show regular people, oh, this little black dot here is very significant, or this white grayish area, this is real. What did you do, whether it was helping show the jury how obvious these misses were, and then can you take us through some of the highlights of what you felt were most effective with the defense expert radiologist?
Sure. So here on normal CT scan, uh, a blood clot will show up as an increased density, and what that means is it's brighter and it's whiter, and so it's not like the black dot, when you're talking, or cloudiness, or things when you're talking about masses in different contexts. Here, it's literally like a bright white object where you shouldn't have a bright white object. And so one of the things that I like to do in radiology cases is take our image and then show it and compare it to like literally the textbook image. And so I had asked our expert to scour the literature and to come up with examples of this is what a CVT of the brain looks like on CT. And what we did is we took those images and we compared them side by side with Allison's imaging, and they looked exactly the same. If anything, Allison's imaging looked even more obvious than the textbook imaging. And so we then get to argue that it is a textbook example. But when I tell you, Brendan, when I first saw it, that it was bright white, and I had jurors nodding and opening, it's because it was that clear, it was that obvious. The defense radiologist was somebody that we knew from other cases, and we knew him to be I'll say on this podcast, a frequent flyer. We have other words for him in other company, but a colleague of Tom and Shanin's had taken his video deposition last year. And what we learned from that video deposition was a couple of things. Number one, this guy had written a positive review of a book that was, the title of the book was something along the lines of how to be a power from within, how to be a successful defense expert witness. And the book was literally about being not an expert witness, but a defense expert. And so what that then allowed me to do once I showed it to him was to go through all of the advice that it gives, or the nuggets in there that he wasn't doing in this case. And the jury loved it. And then the other thing, this was a little more aggressive than I normally get, but I thought that the people of Erie would like it and be taken by it. This guy worked full time through the pandemic for his regular job, and he has a separate company, a separate LLC that he uses for his defense expert job. And we had gotten information that over the pandemic, he had taken over $40,000 in PPP money for his expert work while working full time through the pandemic as a radiologist. And so he just looked like he did not look good.
I can imagine him squirming a bit on the stand.
He did not appreciate the PPP the PPP references, but his whole thing, his spiel was, yeah, I see this, I see these things on there, but I only see them in retrospect. And when I did a blind read, I didn't see them the first time around. So it was not a deviation from the standard of care, because I wouldn't expect a radiologist to see them without the benefit of hindsight and retrospection. And every other expert and every other witness who looked at these studies said that this was obvious. So he just didn't have any credibility.
Given how how obvious the CT misses were, Did you ever have a theory or a motivation for why the radiologist missed them to begin with? I mean, was it one of those situations just reading too many studies or just not, just maybe just had an off day?
So the information that we had was that this guy worked for Foundation. He was looking at imaging from 30 or 40 different hospitals or facilities at the same time. I think what happened was he was looking for a bleed, he was looking for a stroke, and when he didn't see evidence of that, he just moved on to the next one. I think he just didn't spend enough time. I think he probably didn't look at enough cuts to see it. And one of the other reasons why I think he may not have testified is that even when the defense expert would acknowledge, yeah, I see it now, I the defendant himself at deposition said that it was an entirely normal study. And so he was going to say at trial, consistent with his deposition, there's nothing there. When literally his own expert and everyone else was going to say, yeah, there's something there. And so one of the things, that we did differently here, one of the two things that I tried differently was rather than calling this guy as on cross, which is normally my procedure and is something that I have been taught and trained to do by Tom and Shanin. You get up on the tightrope and you have the battle right at the beginning. I didn't want to be too aggressive in Erie. I was an outsider, and I didn't want the jury to think that I was bullying or being too hard on these people. So I made a strategic decision, actually almost on the spot, not to call this witness in my case because it was just going to be a fight, and he wasn't going to agree with me. So what I did was when I called my plaintiff's expert radiologist, part of his examination was to show him the imaging, but part of his examination was to show clips from the doctor's deposition. And I had not done that before. So what I would do is say, all right, Dr. Bardwaj interpreted image 9. Let's see what he had to say about this. Play the clip. Dr. Bittman, our expert, do you agree with Dr. Bardwaj? Absolutely not. Here's why. So it's like teeing it up for the expert with the testimony from deposition, which, sometimes I get frustrated at deposition when I have a doctor who I think is not being straight with me. But I have learned I'm not going to get that doctor to agree that the sun is in the sky and the clouds are white. He's going to say ridiculous things, and I'm just going to be able to use that at trial. So I'm not going to get my satisfaction on the day of the deposition, but I'm going to get him locked in. And then it allowed me in this case to tee up for my radiologist and show the jury just how crazy this defendant was and how he still won't acknowledge what it is that was on that study.
So I think this is great and a good point to make. And I'm sure you've heard among so many, medical negligence practitioners, people are always debating, do you call, the defendant doctor or the, defendant healthcare professional as on cross in your case, or do you, wait for their case? And there's always a debate, pros and cons. I'm very much in your school. It's like kind of people, they came to see it, the main event, why are we putting it off? Let's just get to, what this is about. But I think the true compromise in a lot of cases is showing the video clips from the deposition, and then you kind of get the best of both worlds. I mean, you can, like you did, and maybe doing it with your expert is the best, because if you just show the clips, then you got to designate their stuff too. And sometimes, there's not great stuff that they said against your case also. But when you just show the clips with your expert, you can just show them the best of the best evidence that you have. And now people form that initial impression. And I think it goes a long way. By the time they get called in their case in chief, even after they hear how amazing they are and all the wonderful things they've done, they've already kind of locked that person in at that point.
Right. Yeah. So I've not done, I have done it. I have another lawyer that I work with, not in my firm, but we co-counsel some cases together. And he is a big proponent of let's play the video clips. And so it just got me thinking because I had not really done that before. And then I again, put my own spin on it and decided to play it through my expert. And here it just worked so perfectly because there were discrete topics. We could go image by image, as I did with the defendant in his deposition, and then tee it up because the defendant just said it's normal. There's nothing there. There's no increased density. It's not brighter. When the jury could see with their own eyes that it was much, much brighter. And so it allowed the jury to hear what he had to say in a non-confrontational fashion. And then it allowed my expert to just knock it right off.
Dom, can you talk to us about, the damages component of the trial? So obviously, very significant injury and blindness in a young woman. How did you, whether it was with other witnesses or through your client, communicate the different aspects of damages? And was this, I imagine there was probably an earnings component where there's some economics in addition to the non-economics?
Yeah, there were, and the jury wound up awarding her basically full wages for the rest of her life. So the other thing that we did differently here that I had not done before during the first trial, I had started prepping Allison for her testimony, and I can be a little bit stubborn with how I deal with my clients sometimes. And I was getting really frustrated with Allison because Allison, I thought, had a great story to tell, was intelligent, and was had things that a jury would really like to latch on to. But she was just so closed and so defensive and so unwilling to open up. And there were times, prep sessions during that first trial, where I was getting on her and giving it to her and say, Allison, you are harming your case. You need to open up. And then when we had time, some additional time with the mistrial, I had learned about this company that helps prepare plaintiffs to testify. And I had never used a company like that before. And I decided, let's give it a try here because my methodology is not getting through to Allison. Let's try something different. And we wound up working with these two wonderful young women. And it was sort of a cross between therapy and trial prep. And through their sessions, and I would be participating in the sessions, through their sessions, Allison just blossomed and began to open. And, some of the things that we crafted during those sessions were things that we used to prove up damages in the case. So one of the things that they did with her early on was give her some homework and compile a list. And what they called the list was, what effing sucks about being blind. And then Allison could come up with all the things that suck about being blind. Allison opened up about these incidents that she calls her blindments, these blind moments where she does stupid stuff like baking credit cards or using the wrong things or using the wrong ingredients because she's blind, things that were entirely relatable. And then the most effective thing that came from those sessions, they had Allison write a letter to her younger self, where she could prepare her younger self for what is going to happen down the line. And it was one of the most moving pieces of evidence that I have ever had. And I was not sure what exactly to do with it or how to use it. I didn't know. I didn't turn it over. And ultimately, during Allison's direct, I referenced it. And then because she's blind and can't really read it, I asked her if it would be okay if I read it. And I did. And I don't think that there was a dry eye in the juror box. And we did it. It was the last thing that we did with the last witness on the last day of the first week of trial. And then we sent them home for a long weekend. And I think it was just incredibly powerful. And I had never thought to do that before. And it is surely something, number one, I'm going to continue to work with this group, I think, in the future. But number two, even in the cases where I don't, these are tools that I now have to use with other clients.
I think both of those are great. Can you, I mean, just from a technical perspective, can you explain to us how, like, what was the question set up that got to the point of, hey, I wrote this letter, and then obviously she had it or you had it, and then you reading it. So she was the last witness, and that was a part that became a part of the testimony. So how did you tee it up to actually do it?
Yeah, so I decided I was I was worried that it could potentially draw a hearsay objection. So I had decided what I was going to do was to at the very least reference it. And if I drew a hearsay objection, I'd just read it in my closing because it would have been within the fair scope of the evidence, and would have been something that Allison had talked about and referenced, and then I could just read it in the closing. But I said, Allison, as part of preparing for your testimony today, did I ask you to write a letter to your younger self to prepare yourself for what life is going to be like as a result of these events? And she said yes. And I brought up the letter to her and I said, Allison, is this the letter that you put together? Yes. Allison, would it be okay with you if I read this letter to the jury? And she was actually reluctant about sharing it with the jury. And when she put it together, I think she didn't realize that it was going to be read in public one day, and was a little bit nervous about sharing that. But she said yes. And then I just started to read it. And when I didn't get an objection, and it was only a page and a half, when I didn't get an objection, I just kept going. I was prepared to get an objection, and if I did, like I said, I was going to read it during closing because I think that's fair game at that point. But it was just, incredibly moving in all the ways that her life was going to be affected.
And you pretty much end on that note.
Yeah, yeah. I mean, that's how the jury went home. We rested our case, and that is something that I have been trained. I remember the Goretzka case with Shanin when I second chaired him. We did something very, very similar. We broke right before Thanksgiving, and we offered the most powerful testimony right before Thanksgiving so that the jury could go home and have Thanksgiving dinner with their families and have this fresh in their mind.
Yeah, that's I mean, yeah, just smart trial work by you. Closing argument, obviously imagine you would have probably referenced that to some extent. Any other, approach that you felt was effective, any arguments that you felt were effective in this particular case, and then, talk about how the verdict broke down and so forth.
Yeah, so we created a couple of visuals for the closing to compare and contrast the different experts. The defense called a life care planner, who was this woman probably in her 70s, who was not certified, who spent decades as a school nurse and didn't cite or identify the sources for any of her numbers. And during testimony, my colleague who cross-examined her, Patrick Fitzgerald, elicited from her that her numbers, the sources for her numbers were, quote, my computer and, quote, Google. So we got a good laugh about that. But so we created these demonstratives where we compared the different experts with almost like check boxes. So we did it with the radiology experts. We did it with the life care planning experts where there were like substantial differences of opinion. I have learned from Shanin the per diem argument in closing. I think that it is incredibly effective. I think that it is a tool to be used in these cases where we're talking about damages that are going to last decades. And so what I argued to the jury in terms of pain and suffering and loss of life's pleasures was, look, Allison's going to be alive for another 50 years. I think it's just too hard for you to come up with a number that is 50 years worth. I think that's just too hard. So without telling you what to do, let me suggest another way of getting there and another strategy. Figure out what you believe it is worth by the hour and because one of our themes was Allison was going to be affected by this every hour of every day for the rest of her life. So the jury heard that, I don't know, a dozen times over the course of the trial. And I referenced that, you members, you heard this is going to affect Allison every hour of every day. So for loss of life's pleasures and pain and suffering, let's do it on an hourly basis. What you think is fair compensation on an hourly basis, and then do the math. Do the math for every day, every week, every year for the next 50 years. And that's something that I like to give in closing. The other thing I like to do in closing is give the empowerment speech, where right at the beginning I tell them that they have the opportunity to do something special, that I just get to stand up and make speeches and make suggestions, but they have the power, and it is within their power to do something special here today. And I think that I like that as a speech, and it's something that I use in almost every case.
Yeah, I think that's great. It's important to help them understand that this is not just some run-of-the-mill thing. It's, probably a once-in-a-lifetime opportunity for them. They may never have that much power again in their life. So I always think that's important to remind them of that this is not just a joke, and they're going to have a big impact in a lot of different ways. On your per diem argument, have you ever had any objections to that, or does it usually go in pretty smoothly because you're not specifically suggesting a number to them?
Yeah, I once in post-trial motions had objection to it.
Mm-hmm.
It didn't go anywhere.
Right.
I didn't wind up having any issue. But yeah, I think so long as you don't suggest a number, it's just you're suggesting a methodology.
Right.
And I think, look, we know that if jurors were to adopt that methodology, they're probably going to get to a pretty big number.
Yeah.
Just because of how much time is left in Allison's life. So that is not a reason for it to be objectionable. And I think as long as you steer clear of the number, and I've refined my approach. The first time I did this, I didn't give the jury enough credit. Like I literally told them the calculation, like take the number that you get and multiply it by 24 and then by 365. I don't do that anymore.
Yeah, like we get it, dude.
I give them credit to do the math. And one of my favorite moments of this trial was the jury was out for about an hour and a half. They asked to see my economic report, and they asked for calculators. And
it doesn't get any better than that, right?
I knew I was in a good place at that point.
Yet you're still like thinking like, well, maybe they'll come up with like, they're doing dividing instead of multiplying or something. But no, that's great. Great question. How did the verdict break out? I know it was 7 million something, right?
Yeah. So it was, I think approximately 1.4 for lost wages, somewhere in the area of 3.3 for future pain and suffering, several $100,000 for past pain and suffering, and then the balance of it for future meds. The future meds, they essentially awarded her $50,000 for every year for the rest of her life, which was not the way that anybody told them to do it, and didn't take into account any inflationary factors. But that's what they decided to do. And they also, interestingly, while there was no argument or disagreement about life expectancy, they didn't give her the medicals through what would be her statistical life expectancy. They cut her off at age 70, which I found a little surprising.
You mentioned that they found her 10% comparatively at fault. How did they break down fault assessment amongst the other defendants on the verdict slip?
So we were really happy about this. The 90%, the remaining 90% was attributed solely to the radiology case. So what that means is that we settled with the hospitalists in the hospital. We were getting payment from them. and then we can get the full amount of the verdict and collect it at minus the 10% for comparative. We can get the full amount of the verdict and collect it now from the radiology defendants.
Yeah, that's awesome. That's always, the concern with the joint torts are, are we, yeah, I mean, leaving money on the table for our client potentially, depending on how the fault assessment comes out at trial. But sometimes it can work out magically like that. So I think it speaks to the way you approach the strategy at trial, which is awesome. Did you talk to this jury afterward? Any takeaways from them at all, or were you just too happy and just ran out of there?
No, well, first of all, I never talk to the jury myself. I
Yeah,
try not to
have somebody else
because
do it.
I do, because as our mutual friend Tom Chairs has told me, juries often tell you what they think you want to hear when you have those conversations. So my colleague who tried the case with me, I had him reach out to and interview several of the jurors, and um, there were a couple jurors who believed strongly in the 10%. And there were several jurors who believed that the amount was less than it should have been in terms of the amount of the award. And there were a couple jurors who really dominated the discussions. And what I've learned is that one of the jurors who was not the best for us in that jury room was a woman that demographically you would have thought would have been like the perfect juror for the plaintiffs. It was a young female school teacher. She had purple dye in her hair. Like this was somebody who we thought was like, this is our juror. This is a great juror, and it just goes to show you that the demographics are not necessarily destiny when it comes to these awards.
Yeah, I know you teach trial strategy at a law school, right?
I do.
And I just started my first term doing that at Pitt Law, and we had a class dedicated to jury selection. And I personally am somewhat cynical about jury selection in as much as I don't buy that people, can look into the souls of these jurors in most instances and make these unbelievable. I think there are things that you can do to help yourself improve, but anecdotally on a similar situation where you can't judge a book by its cover. Greg and I tried a case several years ago, and we had done a data study, and it had told us the type of people that we wanted on it. And what we were told is what we did not want was a young conservative guy. Okay, we did not want that. So we get what we believe is the perfect jury, the 12. But number 13 is the young guy. This was during the pandemic. He's got the Punisher, face mask on. We looked at his, online, what his social media looked like, hardcore conservative. And he was what we believe was our death juror. First day of trial, one of the, people that were in our panel breaks their leg and they're out and he's on. And we're very worried about that. So here, we get this, good verdict, and I had someone from my office reach out to people, and somebody reached out to this gentleman that we thought was the death juror, and he actually said he wanted to talk to me if I would be interested, and so I called him, and he said the deliberations were maddening to him because he wanted to award, a number so far above where they came in at. And, he said, they were talking about these completely irrelevant things like we don't want to bankrupt the hospital and, what's the doctor going to do with that verdict? And he's like, that's not what this is supposed to be about. But I always come back to that. And I mean, you had that there. Your ideal, who you thought was the ideal juror, comes back, and she's probably one of your worst jurors back in that group. And I don't know what that says. I mean, you have to do the best that you can with the jury selection, but it will make you go crazy sometimes.
Yeah, I mean, I think there are certain things that you hear during voir dire that are just simply disqualifying. We have a question that we ask along the lines of if you knew that you were injured as a result of something that someone else did, like you knew that you were injured as a result of somebody else's negligence, is there anybody who would not file a lawsuit in those circumstances? And I think that question or something like it has been tested to really weed out the haters. And so, other than that, I don't know how effective our voir dire questions are.
Yeah, I think, I mean, strong beliefs against, money for pain and suffering and things of that nature
Right,
can give you
right.
some clear signs, but you're still dealing with a huge other group of people, and there's a lot of question marks in there. But anyway, man, that's a wonderful outcome, and I assume, are you going to wind up on some degree of appeal at this point, or to be
We, we,
determined?
we are we are right now in the throes of post-trial motions. They have filed for a remitter, asking the judge to reduce the award, and they are arguing, despite the fact that they no longer provide health care in this area, they are arguing that if they have to pay this award, it's going to impact the ability to provide health care in the community. So we are confident in what we have to say on appeal, and we're confident that we're going to be able to hold this verdict.
Well, good deal, man. I'm confident from what you're telling me that it will stand up. I sure hope it does. Your client certainly deserves it. You guys tried what sounds like an awesome case, and congrats, and thanks for doing the Just Verdicts podcast today, man.
Brendan, thanks so much for having me.
Yeah, Dom, if anybody wants to get a hold of you, refer your cases. And I should say, Dom handles all kinds of cases. He's great at MedMal, but I mean, you've done it all in looking at your bio. But if people want to reach out and get a hold of you, talk to you, pick your brain, refer you a case, where's the best place for them to find you?
Sure. So I'm a partner at Kline and Specter. I'm based in Philadelphia. You can find me on the website at KlineSpecter.com, KLINESPECTER. You can also call me at 215-772-1000. The firm is on all social media, and I'd be happy to help.
Awesome. Well, Dom, thanks again, man, and hope to talk to you soon. Take care, bud.
Thank you.
If you enjoy the show, please subscribe to the Just Verdicts podcast on your favorite platform and consider leaving a review. And if you're interested in co-counseling, local counseling, or referring a catastrophic injury case, we'd love to work with you. Call us at 412-281-4100 or visit our attorney referral page at pamedmal.com/refer. Thanks for listening.